Is Linda Appiah. Hopefully you remember me from 2 weeks ago when we did a programme in relation to driving offences and immigration matters about driving offences. So this week we are going to change the topic slightly, and hopefully you'll see it on your screen, or at least you would have seen the advert for it. We're coming to you from Omega Live TV this evening. I'll be with you for about the next hour, discussing a number of issues with you. Hopefully you'll see on the bottom of the screen the phone number that you can call me on in order for you to have your questions answered if there's anything this evening that you'd like me to answer specifically about the topic today. So what is today's topic? Today's topic is about crime and deportation, all right? So as I said, you can call me in at any time during the hour to answer any questions. You can DM me at any time. Or if there's a topic that you want us to discuss that I haven't touched on yet, and maybe in future programmes we could discuss those, then let me know and then we'll try and help you out by answering those questions. Right, so if we deal with today's topic, I said it was to do with crime and deportation. Again, one thing I realised from the last session, which was 2 weeks ago, was that a lot of people didn't realise or recognise that driving offences were criminal offences. Now, bear in mind, when I say driving offences, I mean those that have been put before a court. So once it's gone to a criminal court, which is always a magistrate's court, then you're in the realm of criminal culpability. So that means that the court could find you guilty or you plead guilty, but either way, you could end up potentially with a criminal record, okay? So I just want you to remember that in relation to crime, driving offences can also be criminal offences, all right? So if you're not sure, check your record, check with the police, check with a lawyer as to see whether it's correct or not that the crime you've been convicted for or any criminal record you have is actually something that you need to bear in mind. The reason why it's important is not just for you to know, but obviously for things like if you're travelling abroad, there are some offences which you need to declare on any visa application you make if you want to travel to the US, if you're British, or also if you're applying for a job, they would need to know whether you have a criminal record or not, all right? So, dealing with crimes, what type of crimes do we have? I have my own sort of category of crimes, and I have those that I call lesser offences or minor offences, then about medium level offences, and then we have serious offences. So serious, I think you probably be able to guess what serious criminal offences are. Murder is a good example, manslaughter, and rape, robberies. Those are all serious offences, okay? But they're an example of quite a few, a long list. And by serious offences, they're ones whereby undoubtedly you are probably going to go to prison for, okay? So let me just mention two of those offences that I've just said, and that's murder and manslaughter. Murder is defined generally as the unlawful killing of another person. And manslaughter is the same, unlawful killing, but there's usually some sort of explanation. So, for example, you were provoked into killing the person. So that would drop a murder charge down to a manslaughter charge. In the US, they have a different system. I'm also sometimes asked, well, what's first degree, second degree? Those are not England and Wales terms. They are American terms, okay? So first degree murder in America, as far as I'm aware, is the same as murder here. And manslaughter is second degree and third degree murder in America, okay? But sticking to this country and the terms that we have here, we're talking about murder and manslaughter, all right? Then I said to you that the second category of offences, the ones that I call sort of middle range offences, are ones that sometimes depend on what you did. So how serious the actual crime was. For a good example, I would say an assault. An assault is the unlawful touching of another person, okay? So, for example, if I pushed you that would be an assault. But it's unlikely that I'd go to prison for something like that. However, if I punched you and I broke your nose, that's also an assault, but it's likely because I have damaged your nose or broken your bones rather, or where the skin is broken, then I'm more likely to go to prison. So depending on the facts will then dictate whether the crime means that a person is likely to either go to prison or not. So that's why I describe those as middle range offences. Minor offences, which again was the third of the categories if you remember. Third of the categories, minor offences, so the driving offences that we spoke about a couple of weeks ago. Most of those are minor offences, so failing to wear a seatbelt. And even the assault that I mentioned, where I talked about a person who you push. So if you push someone, that also would then be classed as a minor offence because of the facts. Okay. Now, I used to do a lot of prosecutions in this country, normally for the CPS, which is part of the criminal justice system. But also there are other authorities that also prosecute people for criminal offences. County councils can do that, so fly tipping, throwing rubbish out of your car or dumping rubbish by the side of the road. It's probably the county council or local authority that would prosecute you in a criminal court for that. Then you've also got things like the probation service. So if you've already committed a crime and you're supposed to report to probation and have further work with probation service, if you fail to do that work, the probation service can then take you to court for failure to complete whatever task you've been set. Then the RSPCA is another good example. I used to do prosecutions for the RSPCA, and that is for people who mistreat animals. Excuse me, but good examples I have from the past are horses. I've prosecuted on behalf of the RSPCA in relation to a horse case before, and then also animals, smaller animals like your pets. So if you're mistreating your pets, you can be prosecuted by the RSPCA in a criminal court. So we've looked at generally what sort of offences we have. Let's look at what courts these offences are dealt with at. And we've got three types of court. You've got the magistrates' court. Now, about 5 years ago, there were about 330 magistrates' courts in England and Wales. And then you have the Crown Court. The easy way to know the difference between the magistrates' court and the Crown Court is in the Crown Court, generally, the lawyers and the judge are usually wear their wigs and the gowns. So you've seen the white wigs that we wear and the black robes as well, which are called gowns. We usually wear those in the Crown Court, but not at the magistrates' court, because the magistrates' court is for the lower level of offences, and the Crown Court is for the higher level of offences, including up to as well murder. There is a third court, which we have, which is the youth court. And in the youth court, they deal with juveniles, so a child from the age of between 10 and 17 years of age. And the youth courts are a specialist type of magistrates' court. So remember I said you've got the magistrates' court and the Crown Court and the youth court. But the youth court comes technically under the magistrates' court system. And the magistrates' court, the youth court I should say, deal with, as I said, children between the ages of 10 to 17. And usually for offences such as thefts, burglaries, antisocial behaviour and drug offences. But of course, you can start a case, even as a youth, from the youth court or even in a magistrate's court, and then end up in a Crown Court. A good example of this, and I apologise for any distress this may cause using this as an example, but I recall the case of the murder of James Bulger, which took place in 1993. Many of you will know about that case, and that was by two children who were aged 10 at the time. That case started off at a magistrate's court and then went to the Crown Court because, of course, murder is always dealt with at the Crown Court regardless of age. Once a child is from the age of 10, if they commit a crime such as murder, it is always dealt with at the Crown Court. Now, in that case, both boys were sentenced to 8 years, and then they were released on what's called life licence with conditions. So if you're given a life sentence for a murder, some of you would have heard the phrase, life should mean life, but it doesn't. Life in a Crown Court, when such a sentence is given, is then passed to a judge to then pass what we call a minimum tariff. So a judge will say, well, I imprison you to life with a minimum tariff of 10 years, for example, which means you must serve those 10 years. At the end of the 10 years, the parole board in the prison will then check to see whether they think you've reformed, whether you're likely to commit further offences, and if they think you've behaved in prison as a model prisoner, they at that point will then decide that they could release you on licence. So to make sure for the rest of your life you continue to behave yourself. And as in the James Bulger murder case, both of the boys were released as adults at the age of 18, and both went on to be recalled on their licence. That means they were then sent back to prison after their release because they were found to not have complied with the terms of their release. So one of them, I won't name them, but one of them was thereafter found to be in possession of inappropriate photographs of children. So he was sent back to prison for that, okay? So I've given you a bit of information about youth courts and how those end up at the Crown Court, which then has given you an indication of what the Crown Court is. And don't forget in the Crown Court that if you are to be tried, so if you pleaded not guilty and you go to the Crown Court, you are to be tried by a judge and 12 of your peers who are known as the jury. Okay, so then the jury then will decide whether you're guilty or not guilty, and it's the judge that then passes the sentence on you as punishment for the crime. In the Magistrates' Court, the system is different. There is no jury in the Magistrates' Court. In the Magistrates' Court, you have 2 or 3 magistrates. Or you have one judge that sits by himself. So the 2 or 3 magistrates are unqualified. Although they sit in judgment of you, they're unqualified members of society who've applied for the job and they've had some training. So they then sit down and then they hear the cases there are for the date, and they can also decide whether you're guilty or not guilty. In the alternative to the magistrates, as I said earlier, you have the judge who sits as a single judge. And if your case goes on at the Magistrates' Court, that judge will decide also whether you're guilty or not guilty if you're to have a trial. So we've looked at types of offences, we've looked at types of courts that deal with offences. So now I'm going to just take you briefly through sentencing. Sentencing is whether you plead guilty or not guilty. Once you are found guilty, what punishment is meted out. And there are different levels of punishment depending on whether you are in the youth court or in the Magistrates' Court or the Crown Court, okay? The sentencing powers in the youth court, so in relation to children between the ages of 10 and 17, are either to discharge you, so you've been found guilty or you pleaded guilty, and the judges at the youth court say, do you know what, you've been punished enough. The mere fact of you coming before us today, the mere fact of you being in trouble with us is enough, so we are going to simply release you, and then you can go. But don't forget, you still have a criminal record. The other options open to the court in relation to youths are referral orders, which are where the youth justice team will work with you. That's a specialist team that work with children to assist you to not commit any further offences. There's a reparations order, so the court could decide that you are to, for example, give an example of a crime, for example. If a youth were to kick in somebody's door, so kick someone's door and cause some criminal damage, part of a reparation order could be to say that, okay, go to that person's house and go and repair the door. So that could be part of reparation order. Then you've got youth rehabilitation orders, where the court may give you specific tasks that the court says you should fulfil within a specific period of time. Then the last option, and this is of course the most serious, is a detention and training order, which is, Feltham's a good example. There's a Feltham Youth Offenders detention and training order centre in Feltham. So that may be somewhere where you would go between the ages of 10 and 17 if you have committed a crime which falls in those categories. Okay, so that's dealt with kids. So when we look at sentences for adults, and sentences for adults are at the Magistrates' Court or at the Crown Court. In the Magistrates' Court, however, the limit sentencing powers is 6 months, unless there's more than one offence, in which the maximum that they can give you is 12 months. If the magistrates find you guilty, or you plead guilty at the Magistrates' Court, and the crime can mean that you could possibly get a sentence more than 12 months, the magistrates can actually send your case to the Crown Court for a judge at the Crown Court to decide on the sentence. And the judge could give you a heftier sentence, okay, because his sentencing powers are greater. So looking at the possible punishments for criminal offences in the Crown Court, as well as in the magistrates, to be fair, is you could get a discharge, absolute discharge. So much like the youth court, the court could say, look, you've been punished enough, the crime committed is a minuscule, minor crime, so go. So there's no separate punishment other than you being in front of a court that you get. Conditional discharge is for a minor infraction. So if you have committed a crime and the magistrates think, or the judge thinks that, well, I'm going to give you a condition not to go to a particular area or not to speak to a particular person, and as long as you do that for a particular period of time, then nothing further happens to you, then that's the end of it. That's the conditional discharge. Fines are familiar to those of you who've been watching me the last few weeks. A fine is a financial penalty, okay, for the criminal offence. There are also, the next level, community sentences. So community sentence is serving your sentence in the community. Example, unpaid work. So you could be told to, I don't know, go and clean a garden somewhere in a park that belongs to the local authority. You could be given a curfew, so especially if you've got antisocial behaviour at night time. You go out with your mates at night, you get drunk, and you're always getting into fights. That's how you ended up in court. So the court might say, just to help you to stop doing that, from 8 p.m. to 8 a.m, stay at home. We'll put some sort of tag on you. So if you leave the house between the curfew hours, the police will come and get you. So that's usually a good incentive to obey the terms of a curfew, all under the umbrella of a community sentence. Then the last and the most serious, of course, of the punishments for criminal offences is a term of imprisonment or custodial sentence. Custodial sentences have a maximum. That maximum is usually set by Parliament. So you wouldn't know what it is unless it was relevant perhaps to you and you sought advice from a lawyer before you would know what the sentence is that's passed on you. For example, robbery, 14 years is the maximum. So there are lots of examples. Like I said before, murder, life imprisonment. So all of these types of offences all have the maximum terms of imprisonment. And there is a broad discretion from the judge as to what sentence to pass on you for the offence that you have committed. All right? So, if you are unfortunate enough to find yourself before the criminal justice system, you've seen that there are a wide range of powers that both the Magistrates' Court and the Crown Court could have, depending on the severity or seriousness of the offence. Now, I've taken some time to go through all of that and give you the list and take you step by step through all of those processes, because all of this is not only just important for a person who's committed a crime, but really, really important, especially around now, in relation to deportation. Okay? Now, what I will tell you is my big headline is deportation is different from removal. Okay? Now, some people will know this, but in the media, often the word deportation is used over and over and over again. But since 2000, deportation generally has only been used in relation to criminal convictions and criminals where that person is to be forcibly taken out of the UK or England. It does not apply, for example, to somebody who simply overstayed their visa. If you overstayed your visa, you came into the UK in December last year, you had a 6-month visitor visa, so you should have left technically in May. Okay. If you didn't leave in May and you're still here, and we're now where, in July, then you would be considered an overstayer. As an overstayer, if the immigration authorities catch you now, you will not be deported, you would be removed from the UK. Yeah? Deportation, as I said, generally relates to those who've committed criminal offences. So, how do we get ourselves into this sort of trouble? I don't know if any of you saw a recent article that was in The Guardian, I think on the 7th of July or so, in relation to twin boys from the Caribbean. They are brothers, and they committed offences of assault. From what I understood from reading the article, they were 2 separate incidents. So it wasn't one incident where they were both involved. And they were both sentenced for the separate assaults separately. The problem then is that when they came to this country, they were children, very young. They've stayed in the United Kingdom all of their lives then, so maybe from the ages of 2, 3 or whatever, stayed in the UK and then reached the age of 18. Then at the age of 18, because they've committed these criminal offences, the Home Office have written to them or indicated to them that you are a foreign criminal and therefore we are going to deport you. Yeah? In the past, I have had, even currently, had quite a few young, especially black boys who have been found guilty of a number of criminal offences and are on the road to deportation. If the criminal offences were committed when you were a child, so before the age of 18, they're a little bit easier, not significantly, but a little bit easier to deal with, depending on the severity of the crime. Once you reach the age of 18, you really are supposed to know what is right, what is wrong, and there's not really much room to say, well, I was a child, I was naive, especially if you committed the crime when you were 18 years and above, okay? So the real threat to people is that they could be deported. You serve a prison sentence for 2 years for an assault, for drug offences, and then suddenly you find the Home Office write to you, either when you're still in prison or after you've just come out of prison, or even maybe 2, 3, 4 years later. And they say to you that, well, we don't think you're someone who we desire to be in the United Kingdom, and so therefore we are going to deport you. Deportation is automatic for anybody who has received a prison sentence of 12 months or more. So as soon as you have a prison sentence, so it's not how long you serve, it's how long the judge gave you. Okay, so if the judge says you are to be sentenced to 12 months imprisonment, then know that you are on the road to automatic deportation. If, for example, the judge says you're sentenced to 6 months, then you're not on the road to automatic deportation, but there may be a time when the courts would say to you, or not the courts, rather, the Home Office rather, would say to you that, look, you got one prison sentence where you got 6 months, another prison sentence where you got 3 months, another prison sentence where you got 9 months. You keep getting into trouble. You are now classed as a persistent offender. And if you're a persistent offender, we don't want you here. As a persistent offender, you must leave the United Kingdom. And so you're put into a position where you are told, if you don't go under this deportation order, we will deport you ourselves. So they will come and take you into detention and then put you on whatever flight arrangements they have to take you out of the United Kingdom, okay? But when you have, as I said, a 12-month sentence, or you're called a persistent offender, it's not necessarily the end of the road. But I put the matters as serious as I have because once you're on the road to deportation, it is a real challenge to get people off the road to deportation because you're already starting from a position of somebody who has behaved badly. And the UK government's policies, as we know in the past when they've talked about a hostile environment, include deportations. There were cases earlier in this year of a plane full of Jamaicans that were going to be sent back to Jamaica, and the suggestion that they were all foreign criminals. Some were able to stop their own deportation or removal, and others weren't, and they were actually sent back. They're not alone, especially when it comes to things like gang violence. If you are seen as part of a gang, then once your sentence is over 12 months, you are inevitably on the road to deportation. Okay. So what can you do? As I said, they will write to you first, and then they'll say to you, right, we're thinking of deporting you. What do you want to tell us? So at that point, you then write back to the Home Office and tell them everything that you can. And there are two general areas that one argues when looking at a deportation case. The first is for reasons of asylum, which I'll explain. I shouldn't be deported. And reasons of human rights is number two. Okay? So looking at asylum. Asylum is because of my political opinion or beliefs, because of my religion, because of my sexual orientation, because I'm in an ethnic minority in my country that's persecuted, or because I'm a woman, and women are generally controlled in our country, I cannot be deported because I'm going to suffer as a result of one of those things that I've just mentioned. So there are various specific headings, yeah? I'll give you a funny story of one client who I was dealing with her and her children's deportation, and she wanted us to go into court, and she said to me that, she wants me to tell the court that she can't be deported because one of her kids has asthma. And I said to her, okay, which country? And it was an African country. And she said to me, the child suffers from asthma. And I said, well, is it being managed? How bad is the asthma? And she says, oh no, he has an inhaler and he uses it when he needs it once or twice a week. And I have to say, and my general advice is that there is no point in putting forward points that are not going to help you. Telling the court that your child has asthma is not enough. Yeah, if you say, my child has got asthma, then that's treatable in most countries of the world. They have therapies available for most asthma sufferers, okay? So, so put that kind of idea to bed. It has to be quite serious and significant reasons why you can't be deported. So I've talked about asylum a bit. Let's look at the other aspect, and the other aspect is in relation to human rights. I'd said, and there are two parts to human rights. There is your individual human rights, you as a human being, and there are certain factors with that, and there's also your family life. Okay, so the first bit where I talked about factors to do with you, human being, are called private life rights. So private life includes how long you've been in the United Kingdom, whether you came here as a child and have had your education in this country, whether you have friends in this country, extended family members here, you've set up a business, lots of factors to do with you personally and how your development has happened as a human being here. Medical issues. So you may have medical issues that you want brought to the court's attention or to the Home Office's attention that may mean that you can't be deported. So if you have significant illnesses that either mean you can't be moved, or if you were to be moved, once you get to your home country, you're unlikely to survive. Those are the sorts of areas that you look at, yeah? But then apart from that, I'd also said the one that most people argue, which is family life. If you are a young person, then family life will usually be parents. So if you came at the age of 2, you're now 19, you committed your crime when you were 18, so you've done your 12 months and you are living with mum and dad, don't have a girlfriend, don't have a partner, don't have children, then you're talking about saying that, look, I have been with my parents since the beginning. This is the home that I live in, this is my nuclear family. To send me to a country which I don't know, I don't remember, I don't speak the language, those sorts of factors are the factors that the Home Office will look at and consider. On the other hand, if you're a bit older and you're married or have a partner and you've got children, you're asking for them to be considered as part of the equation. Yeah. One area where some people get surprised at is that, by example, if I'm here and I've committed an assault on someone and I've received a 12-month sentence, but the permission or right I have to be in the United Kingdom is that I have indefinite leave to remain, I can be deported. If my indefinite leave to remain also extends to my husband and my children, and they live with me, and my children are under the age of 18, my husband can be deported and my children can be deported. So they deport us as a family because of my wrongdoing. That is very possible. The only ways in which people usually are able to be considered alternatively to the scenario I've just given is if, for example, they are British. So if your children are British citizens, then it's going to take quite a bit for the Home Office to suggest that your British children, especially if they've been here for a while or were born here, should be deported with you. If your spouse is British, it would be difficult to argue that your spouse should be removed with you. You note I said difficult, not impossible. Yeah. So whatever the crime is, it's the crime I find that tends to dictate how seriously and how hard the Home Office push the deportation issue. So, excuse me, I'd said that you tell the Home Office that I'm married, I've got kids, I don't want my family to be removed with me. So please let us stay. We've got everything in the UK. We don't have anything in our home country. I haven't been there for 20 years. And the Home Office says, tough. You've still got to go. The crime you committed makes you undesirable to stay in this country. What do? You can then, at the point the Home Office says you need to go, you can then appeal that decision. Sometimes the Home Office give a decision that you cannot appeal and you have to go to a different court and it becomes a bit complicated. I always advise people that when it comes to deportation, don't do those by yourself. Yeah, because the law is too complicated, the pitfalls are too many. You really do need legal advice and guidance. Because if, for example, the Home Office write to you and say, we're not going to give you a right of appeal, you can't appeal whilst you're in this country, go back to the country that you're from, you can appeal from there. Then you need to know the legal resolutions available to you because of that, okay? We've just got a first caller come in. So let me just break here from what I was talking about and take our caller. Hopefully we can hear him. Hello, caller?
Yes, hi. Okay.
Hello?
Yeah, hello.
Hello, caller?
Hello.
Let me just check.
Yes, hi.
And see whether... Hello? Just hold on for a minute.
Hi.
Hello?
Yeah, I got a question.
Yeah, hi. Can you
Hello.
give... Sorry, can you just hold on? Can you give your name, please, and where you're calling from? Hello, caller? Hello? Can you hear me? Oh, hello. Are you still there?
My name is Frank Mensah.
Okay, yes, Frank Mensah. How can we help you?
Yeah, hello.
Yes, Mr. Mensah, you want to ask a question? State your question, please.
Sure. Yeah. Please, I'm calling from US. I'm calling from Utah.
Okay.
But I got a question for my friend.
Okay.
Yeah. I got a question for my friend living in UK.
Okay, good. Tell me what your question is. Hello? Hello, yes. Please state your question. What's your question?
Okay, my question is, if you have resident permit, which is indefinite in UK, and at the same time you have a criminal record, can you be a British or not?
Okay. Yeah, that's a good question, actually. Thank you for that question, first of all. And I didn't know we had people listening all the way from America, but that's cool. In relation to criminal offences where the Home Office then have to consider you and whether you can be a British citizen, if you normally have to have indefinite leave in order to become British, okay? So let's assume that, as you said, your friend's got permanent stay, but I'm going to assume it's indefinite leave he's got. It depends on how significant the sentence was. If your friend was convicted of a crime where he received a prison sentence of 4 years or more, the sad news is he can't be British. He is unlikely to ever be allowed to be a British citizen. Anything less than 4 years, it depends on what they call the rehabilitation period. Some of the sentences, depending on the crime and depending on how long ago you committed the crime and how many years you were given for the crime, or have a rehabilitation period. So depending on the crime, as long as the sentence was less than 4 years, there is hope for your friend, okay, that he could actually then get out of it and become British. But by all means, you can direct message me afterwards and just let me know the exact details, and then I can give you more specific advice depending on your friend's circumstances. Yeah, does that help you, Mr. Mensah? Hello, are we still there? Yeah, does that answer help you? I think he's still with us. Does that answer help answer your question, or do you want to ask anything else?
Yes, please. Thank you very much. I'm very sure it's less than 4 years, so
okay.
You guys need to hurry up.
Okay, good. So you can always direct message me, and if you direct message me, I can let you know what I think in terms of the actual sentence and how long before he can become British. Okay. Hello. Hopefully that answers your question. Is that all right?
Okay.
Oh, I think he's gone. Okay. Well, hopefully that's answered that caller's question. So yes, you can become British, but again, it depends on the sentence. Depends on how long ago it was as well that you committed the crime. So by all means, do message me. As I said, I think it's Mr. Mensah. Please do message me, and I'll be able to give you more information. All right. Yeah, so where I got to was I was talking about the fact that your family members could also be removed from, or deported rather, from the UK with you, and the fact that you would have to put forward to the court reasons as to why you should not be deported. and that's by way of challenging the Home Office decision to deport you. So what would happen would be the Home Office would write and say, well, why shouldn't we deport you? You say why they shouldn't. They then decide perhaps to make a deportation order. You then can go to a tribunal and challenge that decision to deport you. And what it would be, as I said before, on asylum grounds. It could be on human rights grounds. One change that is coming our way is in relation to EU nationals. At the moment, EU nationals can only be deported on specific grounds. Usually, things such as national security issues, where they're such as public policy, public security. Those are the only real reasons why EU nationals can be deported, and it depends on how long they've been in the United Kingdom as well. If the courts do decide to deport an EU national, that you can't bar an EU national from coming back to the UK. That's the strange part of it. As long as the person says, I'm coming to work, etc., you could always deport them and they could easily come back to the United Kingdom. So you see how the law's been quite generous to EU nationals. We've got another caller. Let's just see what he wants to know. Hello, caller.
Hello.
Hello? Oh, it's a lady, sorry. Hello, yeah, caller. What's your name and where are you calling from?
My name is Melissa. Melissa Boku.
Okay. Yeah, how can I help you?
I just wanted to ask, what criminal offences are there that would mean that I might get deported? Well, not me, sorry, that someone might get deported.
Okay, so
what sort of criminal offences?
Okay, it's not only is it the offence, it's also mainly how long did you go to prison for? Okay, so for example, you could commit an assault against somebody and go to prison for 6 months. That would not normally mean that you're about to be deported. If, however, you commit another assault and you're given 12-month sentence, that would automatically mean that you are on the list of deportations. So if you're on the list of deportations, then you have to convince the Home Office as to why you shouldn't be deported. So it's not necessarily the offence, although some offences automatically you're going to get a sentence of more than 12 months anyway. But it's normally to do with how long you went to prison for. So I hope that answers your question. Hello?
Yeah.
Yeah, does that answer your question?
Yes, it has.
Are you sure? You sound hesitant.
Yeah. Okay. But will you put your details up in case I might need to contact you?
Yes, yeah, of course. Yeah, your number's come up, so we'll message you after this, and then if you have anything further you want to ask, then by all means you can contact me, all right?
Okay.
Thank you.
Bye.
Thank you for your call, caller.
So much.
Thank you. Bye-bye.
Okay.
Okay.
Bye-bye.
Thank you. So we're now talking about, we've gone on to start talking about EU nationals and EU nationals with a right of residence in the United Kingdom, and how it's very difficult to remove people like that because there are very specific grounds. So you can imagine if, for example, an EU national commits an assault. So assault seems to be a good example here. Assault cannot be classed as public security, a public security breach. So it probably means the EU national is not going to be deported. But as I said, if they are deported, they can always come back. So it's quite difficult for the UK in relation to such persons. That, however, big headline, is going to change. As most of us know, we've already left the EU, technically. But we're now on a route to actually having a number of things that the UK government needs to sort out with the EU. So a sort of transitional period, I would say, we're going through now. Sorry, we've got another caller. Let me just deal with this and let's see what this caller wants. Hello, caller. Can I have your name, please, and where you're calling from?
Hello,
Hello, yes, caller. Your name and where you're calling from, please.
it's Winnie.
Yes, hello. Yes, Winnie. How can I help you?
Well, I just want to know where the law stands in terms of people who have committed offences and have been deemed to be mentally ill.
Okay, sorry, do you mind being a little bit more specific? So where the law stands with people who are here with indefinite leave to remain, or are we talking about specifically in relation to criminal law
if
only?
somebody has committed a crime, for
Yes.
instance,
Yes.
killed someone,
Yes.
and they are deemed to be like having mental health issues.
Yes.
Where does the law stand on that one?
Okay. Yeah, thank you for your question. It depends on the crime, again, and the severity of the mental illness. You gave the example of murder, which is a very good example. At the top of the programme, when I talked about murder, I also mentioned manslaughter. And what usually happens in the case of a person who's committed a murder, rather than call it murder, it's oftentimes, not always, but oftentimes dropped because of mental health reasons to manslaughter, yeah? Which means that the person will then probably be admitted into a mental institution. Once they're admitted into a mental institution, they are kept there and monitored until such a time as either they get better and so then could possibly be released into the community, or they then get better and could possibly then go into the general prison population, so into a normal prison. And a good example of one of those types of institutions is Broadmoor, which you may have heard of, where they detain and keep a lot of people who have mental health problems, who have committed crimes. Yeah, does that answer your question? So it really just depends.
Yeah, thank you.
No
And
problem.
thank you for the very good work you are doing as well.
Oh, my pleasure. Thank you.
Thank you. Right.
Thank you. Thank you very much, Mercy. Thank you. Oh, it's Winnie rather than Mercy, sorry. Okay, that's lovely. So thank you for that, caller, and thank you for all the questions that you're asking. Okay, so as I said to you, I think we just finished with the EU nationals, hadn't we? And I just said to you that the law was just about to change. Because the UK left the EU in January of this year, it means that once we reach January of next year, it's all change. So the generosity of the system to EU nationals is not going to extend any further. So once we've left after the 31st of December, the plan from the government, as far as I can see at the moment, is that EU regulations which protected EU nationals and their family members would no longer exist, and they would then be brought in line with the rest of the world. So where I talked about 12 months prison sentence and all of that, they would then fall within that category, okay? So a lot of them would not be able to take advantage of the system perhaps as they had before. The only good news about deportation is once they have tried to deport you once on a particular crime, and let's say you were successful, you won in front of a court, they can't deport you again on the same thing. It have to be that you've committed further offences which fall into the categories that I've explained. Perhaps the last point that I'll deal with is with, I'd mentioned indefinite leave to remain. If you are on a deportation order, and again you're successful in winning your deportation appeal, you will not be given back your indefinite leave to remain. The Home Office will take away your indefinite leave to remain and give you a period of stay in the United Kingdom for up to 30 months. And so not only does it affect you in terms of your immediate future, but it then puts you at jeopardy, of course, for your long-term future. And as one of the callers had asked me, your ability to become British is then affected. Yeah, so I hope that you have all found this evening interesting. I hope you've all been able to follow what I've been talking about and the information that I've provided to you. In terms of to remind you of who I am, of course you should know hopefully by now, my name is Linda Appiah. I'm a barrister at Fine Court Chambers, and we are being sponsored this evening amongst many by World Remit, and that's the money transfer company that I hope you all are familiar with. I certainly am. And so this evening, hopefully you've got the information you need. As I said, direct message me. You can text, you can call if there's any further information you need from me in relation to this topic and future topics that you want us to discuss. I hope that you've enjoyed it and found it interesting. And without further ado, I'll bid you